I would like to go ahead and introduce our guest speaker for today. Michelle Hanlon is here. Oh, it looks like I have to admit a couple more people. She is the co-director for the Center of Air and Space Law at the University of Mississippi School of Law. We are so excited to have her here today. She has a unique thing that her students are doing. And so I am going to turn it over to her. And I made you a co-host, so you should be good. Thank you, Michelle. Tell us a little bit more about what you have going on.
Thank you. Let me share my screen.
Okay, and you should be able to. Let's admit all here. There it is.
Are you guys seeing the PowerPoint?
Yes.
Yep. Perfect. So first of all, thank you so much for having me come on. I wanted to, let's see. There we go. So I just, drones, first of all, full disclosure, I'm not a pilot. My son is, and my son has also done a lot of work with military drones. And he essentially was the first person to really get me involved in this space, but I will absolutely blame my students. I teach private aviation law and I teach space law here at the University of Mississippi. And I had a bunch of students come to me at the beginning of last year and say, you know, we really think drones are the next big thing, you know, forget space, let's stick to terrestrial stuff and think about drones. And we're really at a crossroads here with respect to the law, because as I'm sure all of you know, the FAA licenses drone pilots, but all of the other laws related to drones are piecemeal, state by state, privacy, torts, you know, everything is just, the states are coming up with their own regulations, and we'd like to, at the Center for Air and Space Law, we're really focused on trying to convince states to adopt laws and regulations that will promote rather than hinder the drone industry. And in our research, we've seen that there's been a lot of sort of this cringe, like, oh no, drones, like, and we really try to get underneath that and understand why people have this sort of knee-jerk reaction to drones. And so this was the focus of our research. I worked with a group of students. We are publishing, hopefully by the end of this week, our very first journal of drone law and policy. And we're hoping to spread that out digitally for free to everybody. And so what I want to share with you today is just some of the research we've done, which I think you'll find interesting. And I know the lawyers talk a lot, so I'm going to try and get through my slides really quickly. I'm going to take you to March 2020, the beginning of this whole pandemic, right? Because what we're seeing, we think this pandemic is actually an opportunity. You know, we're going to go back to Westport, where this was ground zero for Connecticut's COVID. There was a 40th birthday party, 50 guests attended. They had a buffet. Some came from New York, some came from Johannesburg. They shared a lot of food and wine, and they also shared coronavirus, and then they scattered. So Westport, which is a town of 28,000 people, just about 40 minutes north of New York City, did not have a single case of coronavirus on the day of the party, and yet 11 days later it had 85 cases. So Westport, with less than 1% of the state's population, had 1/5 of the state of Connecticut's infections. By April 21, Westport had 197 confirmed cases, and Fairfield County itself, where Westport is located, also very close to New York, but it was averaging 1,500 to 2,000 cases a day. So First Selectman Jim Marp of Westport and the Westport Police were eager to implement what they called the Flatten the Curve pilot program, prepared by the drone company Dragonfly. It's a program that promised to effectively monitor social distancing and ease the spread of COVID-19 and keep the people of Westport and the police personnel safe. They made it very clear that the goal is to provide better health monitoring, and they made it very clear that it will not be used, these drones would not be used in individual private yards, nor would they employ facial recognition technology. So the pandemic drone would be equipped with a specialized sensor and computer vision system that can display fever temperature, heart respiratory rates, as well as detect people sneezing and coughing in crowds and wherever groups of people may delegate or congregate. So the pandemic drone, as they call it, had two functions. One was to just be eyes and ears in the sky to make sure people were social distancing. And the second was this concept that we would be able to actually see if people had a temperature, which is technology that China used quite a bit in Wuhan. I don't know if you saw the pictures with the drones outside the apartment buildings, checking temperatures of residents inside the building. So as you can imagine, the reaction was swift. Westport is home to one very activist, pro-privacy person, and so he immediately assembled a protest, and it was caught up by the ACLU of Connecticut as well, which David McGuire described it as an example of privacy invading companies using COVID-19 as a chance to market their products and create future business opportunities. The main concern of the ACLU was that any new surveillance measure that isn't being advocated by public health professionals and restricted solely for public health use should be rejected. They talked about this is the kind of society we want to live in coming out of the coronavirus. Do we want to be in a police state or a free society? And that language actually mirrored sentiments in the Wall Street Journal article that was published just a few days before, saying the coronavirus crisis could become a watershed moment similar to the 9/11 attacks, which ushered in new government surveillance powers around the world in the name of protecting public safety. And so we actually reached out to the ACLU to talk about what the main concern was. What is it that they are concerned about protecting? And it's interesting because they first of all, they did not believe that this drones could actually detect fevers in a responsible and efficient way. But the main concern wasn't so much this particular act violated privacy, but that the more and more that we saw drones in the sky and the more people got accepted and acclimated to them, then the more they would accept what they called a surveillance state. So we just thought that was a really sort of interesting take, because that's not something you can really fight against, right? Whether as an industry or legally, this sort of fear of surveillance. As you can imagine, or perhaps you already know, Westport reversed itself and decided not to proceed with the pandemic drone. They sent out a press release, we heard and respect your concerns and are stepping back. They're not using drones at all now in Westport. So we wanted to take a look and what happened? Why did Westport step back from this great idea to, at the very least, be able to see people if they were social distancing? So people are private. Ironically, the same people who willingly upload sensitive information to the internet every day, every hour, including GPS tracking information, have a really knee-jerk reaction to this concept of the surveillance state. And even though people are uncomfortable with the amount of personal data they feel maybe floating out there in the cloud about them, they feel like they put that information out there on the cloud. In fact, according to a Pew Research poll, although 97% of Americans have been asked to agree to a privacy policy, only 9% have actually read one. So I would suggest that with cyberspace, there's nothing tangible to fear. So consider the fact that no one seems to complain about that data flowing from their smartphones, right? Because you can't see it. You don't see your privacy being taken away. Conversely, when you're talking about a drone, you have hardware right there to draw both ire and fear of the crowds. And who can doubt that the surveillance capability of drones is infinitely comprehensive and adaptive? It's able to record location information, photograph, videotape, audio tape, thermal imaging, facial recognition, and even intercept cell information. So in short, drones are a visible platform for all of the other things that make people nervous. There have been a lot of articles, and we read a lot of them, about why people think drones are creepy. We came up with three primary reasons. First is the fact that people are generally uncomfortable with new technology, right? And drones are a double whammy. Not only are drones themselves a new technology platform, they are a platform for all sorts of other new technology. So it's a double whammy. It's like this knee-jerk fear. The The second reason is that the public has yet to separate military drone use from civilian drone use. And so when a lot of the public thinks about drones, they think the military uses drones to spy and to destroy. And that's something that we're not moving away from in the civilian use. And not to mention the fact that the media tends to highlight drone use, illicit drone use, right? We always hear about the stuff in the sky or drones going over private property, and not enough about drones being used to save lives and deliver medicine, and now to there's a company that's now using drones to clear stadiums of the COVID, spreading the sorry, I'm just blanked, antibacterial, I'll just call it. So figuring out how to, so as a result of all of that, drones are perceived as a nuisance, something invasive that we want to keep out of our lives and certainly out of our line of sight. We just determined that figuring out how to counter these knee-jerk reactions requires an understanding of the US public's relationship with privacy and government surveillance. So we looked and we said, what is privacy? There's a lot of different definitions, but we like this one because it's control over knowledge about oneself. It's really an important concept. It's about control. So when you think of privacy in terms of control, you understand this knee-jerk reaction to tangible hardware that is viewed as taking that control away. So if you're on your phone and you're giving out information, or you've put your GPS tracker on, you're controlling that. You've decided to do that. Whereas drones, no, it's just there. So it's also important to understand modulation. Most people are okay with losing control over general facts, but not details. And this is important because that's something we also think about with drones. What details are drones able to determine? So our right to privacy flows from the common law, but, and this is important, even under the law, the concept of privacy, the rights it affords is flexible. It's redefined from time to time as a result of social change and as a result of technological advancements. So privacy is not a line in the sand. Privacy isn't, okay, that information is private, that's not. Privacy is always changing. Drones, like I said, are a new platform for technologies. So when we talk, and a lot of these technologies have already had litigation about their invasion of privacy. And so in many ways, when we think about drones, we're nothing new. These are things that have been litigated over and over. And so when we talk about privacy, we need to think about the Fourth Amendment. The right of the people to be secure against unreasonable searches and seizures. So that's the right of the people to be secure against unwanted surveillance. Again, privacy rights, even under the Constitution, even under the Fourth Amendment, are continuously evolving as technology evolves. And since the beginning of the 20th century, the Supreme Court has struggled to find the balance between technological advancement and individual privacy interests. So think about it. Look at the wording of the amendment. Does personhood extend to someone's phone? Does a house include a backyard? Do papers and effects include emails and text messages? And above all, what is unreasonable? That is a term that constantly is being litigated. So up until 1967, the Supreme Court had held that you need to physically intrude on a person or that person's home in order for a search or surveillance to be unreasonable. That means you actually have to enter the home and put a bug in a lamp or on that person. In this case, Katz v. United States changed that. There was a suspicion that the defendant was gambling by phone. So the police put a eavesdropping device outside of a public phone booth. So outside, there's no home there, nothing. Katz was illegally convicted based on what they found, the conversation they picked up. And under prior court decisions, Katz would have lost because neither he himself nor his home nor anything he owned was violated. Here, so Katz court wasn't happy with that result. All the cases I'm going to talk about are Supreme Court cases. Katz said instead, a person has a constitutionally protected reasonable expectation of privacy if the person has exhibited an actual subjective expectation of privacy, and the expectation must be one that society is prepared to recognize as legitimate. So it's a very important two-part test. Did you exhibit an actual subjective expectation of privacy? But that has to be countered by, is it one that society is prepared prepared to recognize as legitimate. So you can't say, oh, I thought I was private here, and the rest of society said, no, you wouldn't be private in a swimming pool or whatever. So here the courts found for Katz because he was able to shut that phone booth door and created a box for himself that he considered private. So the question is, you know, and this is that not been answered, but what about you're talking on the phone on the corner and there's a bug outside a building on the corner of a street? Do you have a reasonable expectation of privacy? Unknown. When we think about the evolving concept of privacy, I want to walk you through what we call the aerial surveillance trilogy. These are cases involving aerial, though not drone surveillance. We don't have any Fourth Amendment drone surveillance cases at this point. Most of you likely know that in all of these cases, the court found that evidence gathered by law enforcement through aerial surveillance did not violate the Fourth Amendment. In California v. Sorello, the police obtained a tip that the defendant was growing marijuana. The defendant had marijuana growing in his backyard, but his backyard had high fences, right? So if the police had actually like put a ladder against the fence and peeked over, that's unlawful, unreasonable. But flying over, using navigable airspace, perfectly reasonable. The court said absolutely, it's navigable public space. If you saw that from public space, it's a reasonable search. Dow Chemical, same idea. Dow Chemical, this was an EPA case. EPA wanted to see certain of the processes that Dow Chemical was using. Dow Chemical had a big fence around. The EPA flew over. It would have been exactly the same, except in Sorello, they used just a 35 millimeter camera. In Dow Chemical, they used a special mapping surveillance camera. And so Dow Chemical said, well, okay, yeah, they were in public space, but they were enhancing their ability to see, and that's not right. And the court actually said, well, yeah, we understand that they were enhancing their ability, but it's fine because the technology they were using is widely available. And so that's why we call it the can you buy it at Walmart test. So according to the court, you know, if it's something that the public can purchase, then it's reasonable. So the court in this case actually said, well, yeah, we're going to grant this, but if you're going to talk about like using a satellite to remote sense and get imaging, that's different because that's not a publicly available opportunity. Although arguably nowadays, anybody can buy that remote sensing imagery. And so I'd be really curious to see what the court said there, but that's my other space law hat. Finally, in Florida v. Riley, same case as Sorello, except it was a helicopter. So, and the court considered that, you know, it didn't matter what kind of aerial vehicle was used, whether it was fixed wing or not. But the court sort of added a new idea. There's no reasonable expectation of privacy, even, especially if the normal use of property was not interfered with. So if you're not interfering with the property, you're flying over in public space, you're using something you can buy at Walmart, that's all reasonable. So because thermal imaging was used in the pandemic drones, thought it would be useful to mention Kylo. Here the Supreme Court held that the police use of thermal imaging technology to detect whether marijuana was being grown inside a home was considered a violation of a reasonable expectation of privacy and a violation of the Fourth Amendment. Justice Scalia, writing for the majority, said, whereas here the government uses a device that is not in general public use to explore details of the home that would previously have been unknowable without physical intrusion, their surveillance is a search and is presumptively unreasonable without a warrant. This is a 2001 case, okay? Now 18 years later, 19 years later, thermal imaging is widely available. You can buy it at Walmart. So this case would be decided differently today. Finally, US v. Jones discussed the constitutionality of attaching a GPS tracker to an individual's car to monitor the car's movement. The court found that people do have a reasonable expectation of privacy in the movements of their vehicles, but I bring this case to your attention because I think it poses, Justice Sotomayor poses two questions that we need to answer that pertain directly to drone use. First, should people reasonably expect that their movements will be recorded and aggregated in a manner that enables the government to ascertain more or less at will their political and religious beliefs, sexual habits, and so on? So this is something that pertains to drones, especially these pandemic drones and social distancing. Is that something that people should reasonably expect? And indeed, how do we counter the concern that awareness that the government may be watching chills associational and expressive freedoms. So knowing that the government is watching will make you stop congregating. Well, arguably today, we want drones to chill that association, right? That's the whole point. So you see this evolution of the concept of privacy is completely turned on its head. So what does this jaunt through the Fourth Amendment jurisprudence tell us? That the concept of privacy is, first of all, when talking about the utilization of pandemic drones, the law is probably on your side, so long as the surveillance is always in a public place. Certainly, being watched by a drone in a public place is no more intrusive than a security camera or a traffic light camera, right? While there's yet to be any Supreme Court jurisprudence regarding what might be a reasonable altitude for flight, so long as the drones remain focused on the public domain, it is not reasonable to expect privacy. Moreover, thermal imaging technology is much more accessible than it was in 2001, suggesting per the Supreme Court's test that it is no longer unreasonable to expect that it is not being employed. But we all know having the law on your side isn't going to change what happened in Westport. But understanding the law offers lessons and guides as to how society might be able to overcome its distrust of drones. And so the product of our research was, how do we reduce this as an industry? How do we reduce the stigma? Well, partner with public health officials. Even the ACLU agrees. That quote from the ACLU said, we can't use drones unless they're endorsed by public health officials. So work with our partners to get that, to make the public health officials agree this is a good way to reduce the COVID. Drawing attention to more invasive strategies, it bears to repeating. You know, having a drone follow you is a lot better than having your phone tracked. I know here at the University of Mississippi, we actually have to assign seats to our students. We get their phone numbers so that, and we track them around the campus. So if one of them gets COVID, we know who they've been in contact with. And that's a lot more invasive than having a drone fly over the campus, right? The Constitution is on our side, so we need to work within it. Keep thinking about this, pushing this evolution. Acknowledge that technology moves faster than the law. So self-police, I encourage the industry to say, okay, we understand there's an issue, but look what we're doing. The state legislator is 5 years away from this, but we can institute these own things. We can teach our own population not to fly over private land and so forth. Publicize more of Drones for Good. Every time at the center, we post as much as we can about the good stories about the drones, delivering library books, delivering vaccines. Public education on responsible drone use. Again, that concept of policing ourselves, make the public more aware of the technology using baby steps. And then transparent cybersecurity measures. It's all about the data. The biggest concern for the ACLU, for everybody, for everyone who's thinking about drones is, this is my personal information. What are you going to do with it? I don't want the whole world to know I have a fever. Once you figure out the fever, who are you going to tell? And that is, I think cybersecurity underlies everything we do, but that is if we can get the drone industry to come out with some guidelines and take actions and take measures that other industries aren't doing, you're going to build a lot more trust. So I just wanted to acknowledge the work of my students, Nestor Delgado, Laura Brady, Capel Gray, and Matthew Russ. Our full analysis is going to be available as part of our Journal of Drone Law and Policy to be distributed, digitally published by the end of this week. And if you'd like a copy, I encourage you just to email me at that email address, and I will send you our issue when it is hot off the press. I'll keep that up there so you can write down my email address, but I'm happy to answer any questions.
That was fantastic. Sorry, Fountain.
Your students have done a great job. Everything that you've mentioned is things that I have really come up against, especially the fact that I'm into aeromedical logistics, transporting medical assets from point A to point B. Now, the case that you cited about the police department shutting down their COVID drone, that specifically geared me towards going to the ACLU for drafting my privacy policy. So I worked with them to do that so I wouldn't have the same issues. In addition, I've actually spoken to the state legislature here in California discussing drone policy, and it's the privacy aspect, period. And you've hit it right on. The one thing I did notice is that there is a patchwork of laws across the country. But if we go and those of us who are operating get our Part 135, that alleviates a lot of that patchwork. So then we follow federal versus each individual municipality's guideline. Um, how do you see that coming about? Do you see that becoming easier for Part 135s to happen, harder, or we're just gonna have to deal with this patchwork?
Huh. I wish I had a crystal ball.
Yeah, because I have mixed feelings about it, but you're more entrenched in the law side of it versus I am. So
Yeah.
here's what your thoughts are.
So I think it's something that's actually in our hands, right? I mean, this is the wonderful thing about having the technology and having states not able to keep up with it. If we are proactive, and my students, for example, have actually written a model law based on our conversations with the ACLU about what we would want to see in a state privacy legislation with respect to drones. I mean, right now, a lot of privacy doesn't even talk about drones, and this is one way for us to show responsibility. And I think we're working with the Mississippi State Legislature right now, but I think if we can, again, it's our job to harness these opportunities to show best practices so that we can avoid that patchwork.
Agreed. And then there's the aspect of inter versus intrastate transportation with drones. Even if somebody brings flies in a widget from Mississippi to California, and then I transport it from California to its final destination via drone, then now it's somehow considered interstate versus intrastate. And because I moved it from California to California, but I received it from somebody else to do the final delivery. That's just crazy.
Yeah, and this is the kind of thing, one thing that's great about US laws is there's always a comment period, right? And so, when things start passing, we have the opportunity to comment and notice how ridiculous things like that are. When the internet first came about, there was a judge, I think in New Hampshire or maybe New York, that said all of the internet is interstate, period. And so it's covered by the Commerce Clause. So everything you do all of a sudden has to be looked at through a constitutional lens. So we saw where that ended up. But yeah,
Thank you so much, Michelle. We gotta wrap up and go on to our rooms. And I mean, this is amazing information, the law side of it. So we definitely, the Spotlight speaker, it's a great opportunity for you guys to connect. So get down her information, continue to have conversations with her. And we're going to switch over. Desi has a couple of announcements. We're going to switch over to our room. But thank you so much. That was really awesome. You had so much great information that we're not privy to unless you're Founts. Because he's doing the big stuff. So
I did put Michelle's information in there. Don't forget to put your information in the chat. Michelle, I put your stuff in there. If there's anything you'd like to add, just add that in there. All right.